We're pleased to be joined now by Daniel Gutman, the attorney for Earnest Jackson. Daniel, thank you so much for taking the time to visit with us today.
Thank you.
Now, before we get to the Board of Pardons decision, I want to make sure anybody watching this is on the same page. Let's set the table a little bit. Now, Earnest Jackson was convicted of first-degree murder based largely on witness testimony that was later disputed in separate trials. And it's gotten to a point now where we have family members of the victim convinced he had nothing to do with the murder, wasn't even there. From the layman, this seems simple. He didn't do it. Get him out of jail. But it's not that simple. What were the complicating factors here that have kept him in prison this long?
Well, I think that's a correct summary that you have provided. I would also add that at Earnest Jackson's trial, he was convicted of first-degree murder, but he was actually acquitted of using the gun. And what that means is that Earnest Jackson's jury believed that he was a part of the event that led to Larry Perry's death, but he was not the triggerman. And of course, two subsequent juries determined that the killing was justified, and another man admitted to that killing. And so what we have here is Earnest Jackson serving time as being an accomplice to an event that two juries deemed justified. It's a legally impossible conviction. You cannot be an accomplice to a non-crime. Getting to your question about complications, you know, our court system and our judicial system often uses procedural mechanisms to not confront injustices that we know exist. And the short answer to your question is Earnest Jackson has been a victim of legal procedure, which has not allowed him to get back in front of a judge to confront this injustice.
Yeah, and so this did go to the state Supreme Court. They upheld the conviction in a decision that I think really underscores kind of how the legal system can get bogged down in semantics a little bit. Basically, it comes down to the difference between newly discovered evidence and newly available evidence. How does the state define the difference between those two right now?
Well, this is an issue that hasn't been litigated for several years. And so at the time, you're correct. They determined that this was not newly discovered. It was newly available. It was a procedural way for the courts not to deal with the underlying problem. And, you know, they said that, look, the two subsequent jury trials in which another man admitted to pulling the trigger and to which two juries determined the killing was justified was not newly discovered evidence. They didn't really expand upon what that would entail. So we're not clear on that right now. It's again, it was litigated a long time ago, but we know that testimony alone is not going to get Earnest Jackson back in court. So we need to be thinking of other ways, creative ways to right this wrong.
So yeah, we get to the Board of Pardons decision this past Monday, made very quickly with very little comment or anything. It was in and out very quickly to the shock of pretty much everyone there. I do want to start with the governor did issue a statement afterward. He mentioned that there were 275 misconduct reports against Earnest Jackson while in prison. But first, can you speak to those? Is that accurate?
I don't know the number. I have not seen the number. I would say that another shocking component of Earnest Jackson's sentence was, you know, we're the only country in the world that sentences people under the age of 18 to life in prison without parole. He was sentenced as a 17-year-old to life in prison without the possibility of parole. He went into an adult facility as a teenager. When we talk about write-ups, this issue of disciplinary write-ups, that can be as simple as mouthing off. We should not be surprised that Earnest Jackson and any other 17-year-old in an adult facility may have said something wrong to a correctional guard resulting in a write-up. What we should be asking is, why are we sending children to adult facilities? And so I don't have the exact number of write-ups, but that shouldn't be a surprise. Anybody with children, we were all teenagers once, and many of us have teenagers. That should not be a surprise to anybody. And it's not a reason to perpetuate an unjust sentence.
I did also want to mention, we reached out to the governor's office this morning. He had said in his statement that there were members of Larry Perry's family that said they were opposed to the commutation. His office did share with NCN 2 statements of family members, one of whom claimed to be an eyewitness, said they believe Jackson is innocent. And we're towing a line between legality and emotions here. How much of what family members of Larry Perry say, whether for or against Earnest Jackson, should be weighed legally in whether or not his sentence is commuted?
Well, I think that anytime someone loses their life, whether it's justified or not, it is a tragedy. And the family members of that person deserve to be heard regardless of what their position is. I mean, that's just a starting point. Now, with respect to legally, that's a tougher question. Our judicial process, and this is another point of criticism by a lot of people, doesn't account very often for victim statements and victim impact. And that's the way it is right now under the current regime. I will say that Larry Perry had a 3-month-old son when he was shot and killed. That child is now 25, and he has come out in full support of Earnest, and his story deserves to be told and heard, even if the legal system isn't listening to it.
Yeah, and that's the thing. It's easy to get mired in legal talk, but at the heart of this are people. The Jackson family, the Perry family, there are people at the heart of this. You deal most closely with Earnest Jackson. That's who you can speak to. Who is Earnest Jackson to you? What kind of a person is he?
Earnest Jackson is an incredibly compassionate and caring person. He has overcome some of the hardest obstacles you can face. He grew up in prison. He went in at the age of 17 or 18, and he has been there for the past 22 years. His adult life is defined by a 4x6 prison cell. It is a horrific existence. Yet, despite that, Earnest is hopeful. He's understanding. He's compassionate. He isn't giving up. He has been made aware of the decision, and he has chosen not to give up. He's going to keep going. That's just the kind of person that he is.
You mentioned keeping going. He's eligible for parole in 2029. That's 7 years from now. Between now and then, what, if anything, can be done to get Earnest's case taken up again?
Well, we've got some thinking to do. We've got some work to do. We are going to be taking a look at the case again to see if there's any way to get this case back into court. But probably more so than that, we're going to be talking to legislators and seeing if there is a legislative fix, if there's any way legislatively to make sure that Earnest doesn't have to wait another 10 years as an innocent man behind bars. I can't speak yet to what the details of that legislation would be because we haven't had those discussions. But essentially, we are looking at any legal avenues and any legislative avenues that could get Earnest justice.
Well, it's a remarkable story with a lot of moving pieces. We've been doing our own reporting on it. Flatwater Free Press has a great article on it as well. You can check it out and read for yourself the story of Earnest Jackson. One of those who's helping to tell the story, Daniel Gutman, his attorney. Thank you so much for joining us.
Thank you.